Hello, my name is Scott Nicoll. I'm a partner with the law firm of Hamilton, Duncan, Armstrong & Stewart, and I'm here to review some of the key terms of the new WorkSafe RMT agreement with you. I'd like to start by reviewing some of the key definitions of the agreement and then move on to some of the key terms. Some of the important definitions. Registered massage therapist. You must be in good standing with the College of Massage Therapy in order to be considered a registered massage therapist under the WorkSafe agreement. If you're not in good standing with the college, you may not provide services to injured workers in British Columbia pursuant to this agreement. In the agreement, you'll see a reference to return to work outcome. This return to work outcome refers to the percentage of injured workers collecting wage loss at the time of the initial visit who have ended their wage loss eligibility within 5 weeks of that initial visit for each RMT in the province. Our return to work outcomes will become important later on when we talk about the rates that you are eligible for treating injured workers. Massage therapy services is also an important definition to understand when you're reviewing the agreement. Massage therapy services are services that are provided by or under the direction of a qualified RMT. They don't necessarily, therefore, have to be provided directly by an RMT, but may be provided under the supervision of a qualified RMT. The last definition that's important for you to understand is liaison committee. Liaison committee is a committee of representatives from both the association and WorkSafeBC whose role it is to meet and to discuss issues of mutual concern between the profession and WorkSafeBC. That's the body that, if there are problems with this agreement or the interpretation of this agreement, or if there are difficulties between WorkSafe and the profession, that's the group that will resolve them. Now, with respect to services that RMTs may provide, an RMT may only provide those services to an injured worker that are set out in the agreement. If they're not there, WorkSafe doesn't want you to provide them. You need permission to treat an injured worker that's already receiving another form of ongoing treatment. That's an important distinction. The other new provision in the agreement, or substantially new provision in the agreement that will be of particular interest to every RMT, are the new rates. The new initial visit rate is $62. By 2015, it will become $65. The subsequent visit rate is now $30, which will be $33 by the year 2015. This agreement expires on December 31, 2015. In the event that a new agreement isn't negotiated before that time, the terms of this agreement will, however, carry over. With respect to the role of your association in negotiating this agreement, WorkSafeBC recognizes the association as the quote-unquote official and authorized body to negotiate on behalf of all massage therapists in the province, regardless of whether they're members of the association or not. Electronic payment technology. Currently, RMTs must submit bills through Teleplan until a different system is adopted. The important point here, though, is that the WorkSafe fully intends to move to a web-based system of billing. You will eventually, and in all likelihood during the term of this agreement, be required to bill WorkSafe through a web-based interaction service. They will assist with funding the purchase of any equipment that you may need, but it will be funded through on a per-client treatment basis. With respect to invoicing, you're responsible to determine the injured worker's claim status before treatment and invoicing. If an injured worker has a claim accepted after you have treated them and they paid you directly, you'll be required to reimburse the injured worker before invoicing the WCB for those treatments. You may not bill the injured worker directly for any service related to their claim, again, once the claim has been accepted. You may not bill for missed or canceled appointments. Invoices must be submitted within 90 days of service to the injured worker, or the WCB can refuse payment. If you're submitting paper invoices still rather than through Teleplan, each paper invoice may only reference one injured worker. And every HST fee item on every invoice has to be coded with fee code 19330. Now, records and audits. As an RMT providing services to an injured worker, you must keep all treatment and business records related to the treatment of that injured worker for 7 years from the last date of service of the injured worker. Your files should be diarized to reflect that requirement. Any request for information, however, with respect to an injured worker, has to conform with any existing guidelines or provisions set out by the College of Massage Therapists. Any requirement that the WC makes of you to provide information or records, you must always first check to make sure that it's in compliance with the provisions expressly stated by the college. If you're not sure, phone the college and ask. The onus is on you as a professional healthcare provider to ensure that you're in compliance with the college requirements at all times. If you're requested, the RMT must allow access to records under this agreement and business records relevant to any injured worker treatment within 7 days. And again, always subject to any provisions the college may stipulate. Advertising. If you're going to advertise that you treat injured workers, you can only permit it to use the term part of WorkSafeBC Massage Therapy Network in any advertising information. No other statement about any relationship with the WCB or an injured worker is permitted. Incident reporting. There will be incidents that you may experience with injured workers in your premises or in the course of your practice. Under this agreement, you're required to report in writing and within 24 hours any alleged or actual injury or trauma sustained by any injured worker while on your premises or as a result of your treatment. Just as importantly, you must also report within 24 hours any threats made by any injured worker, including threats of suicide, to the WCB Corporate Security Department. Insurance requirements. As an RMT, you must maintain commercial general liability policy and professional negligence policies, which, if you haven't already purchased, I know are available through the association's plans. Disputes. If you're involved in a dispute with WorkSafeBC, typically over invoicing, it shall be resolved by the liaison committee. The dispute must be brought to the committee within 6 months of the matter first arising. You should keep that time frame in your mind, because I'm sure that WorkSafe will enforce that religiously. In the event the dispute with the liaison committee arises, a meeting shall be convened within 30 days of the notification to the committee. You then have to deliver your position in writing to the committee with respect to your dispute no later than 15 days prior to the meeting. The WCB then shall deliver their position within 5 calendar days prior to the meeting, and you then can deliver any kind of rebuttal to their position 2 days prior to the meeting. An appeal from the committee shall be to WorkSafeBC's Vice President for Healthcare Services. One of the key provisions of this agreement is the return to work emphasis and outcome. WorkSafeBC's corporate goal is expressed very clearly. Every injured worker should be returned to their pre-accident employment as quickly as possible. In fact, any treatment plan that you provide to WCB as part of your services to any injured worker must include educating the injured worker on return to work. The emphasis on return to work and return to work outcomes is the core of this agreement. Communications with the board. Any reports to a board officer must be in the WCB's massage treatment report form. A template for this form is going to be developed by the liaison committee. The RMT must discuss the alternative treatment or return to work recommendations with the board officer before discussing it with the injured worker. That's an important point because the board wants you to talk about any communications respecting return to work considerations with them before you communicate them to the injured worker. Any communication sent to the injured worker's family doctor must also be sent to the board officer. Now, initial and subsequent visits. The initial visit must include an assessment and result in a treatment plan and must occur within 8 weeks of injury unless prior authorization for the treatment has been obtained by the from the board officer. The RMT must submit a massage treatment report within 3 days of the initial visit. So once the injured worker is in your office, that's the initial visit. You've got 3 days to submit your massage treatment report in the form approved by the liaison committee. For the purposes of determining the 5-week treatment period, the initial visit is day 0 of that period. You have a maximum of 3 treatments per week, and you have a maximum of 15 treatments in total, again without prior authorization. Telephone consultations. Calls will be paid for by the WorkSafeBC when they involve treatment, return to work, or discharge-related discussions. Calls will not be paid for if they are primarily administrative or billing-related in nature. Now, return to work incentives, and this refers to the differential rates that the association negotiated with WorkSafeBC in an attempt to encourage higher rates for those massage therapists who have an actual keen interest in doing this kind of work. After December 31st, 2011, the higher fee codes will continue to be available only to those RMTs notified by the liaison committee that, according to the WCB records, they have seen more than 3 injured workers in the previous 6 months, and that 60% or more of those injured workers have ended wage loss within 5 weeks of the initial visit. You'll recall that we talked earlier about the return to work outcome. This is the significance of that. Massage therapists must have treated 3 or more injured workers in the prior 6 months to be eligible to have applicable fee code reevaluated. In other words, to move either from the lower fee code to the higher fee code or from the higher fee code to the lower fee code, you must have treated 3 or more injured workers in the prior 6 months in order for the WCB to reassess you. The last point that I want to discuss with you is the collection of personal information, and this is an important one. Because you are professional healthcare providers and because of the sensitivity with respect to any information that you may collect from your patients, massage therapists may only collect personal information necessary to perform their necessary services. The therapist must collect the information directly from the individual patient whenever possible, and you must tell the individual why you are collecting it and why it's necessary. You have to take reasonable steps to ensure that no one has access to that information other than those who need to have access to it in your office. Collection, disclosure, or use of any personal information regarding an injured worker must be limited at all times to only those absolutely necessary and authorized to have access to that information. As a therapist, you must not store any personal information about injured workers on any computer services or any other storage facility that exists outside of Canada. Again, this is with respect to the WCB agreement specifically. Any employer or contractor that you employ or contract with must attend an annual Freedom of Information and Protection of Privacy training session. Those sessions will be coordinated annually with the association. If you have any inquiries specifically relating to the management of personal information of injured workers, you're required under the agreement to talk to the WorkSafe FIP coordinator at the phone number listed in the contract. Thank you, and if you have any questions, please see the information on the website where you can obtain further information about this agreement.